Well, you have two vehicles. Mr. Dolangowski was using the vehicle, the Odyssey.
Not while it was at my house, I was using it.
So you needed a rental vehicle because Mr. Dolangowski had the other vehicle, correct?
And she has every right to do so. Do they share expenses?
The dog business seems to be intertwined.
My client has a personal relationship. If this was just a question of someone dating someone, then that would terminate everybody's spousal support. We already know that someone having regular sleepovers does not satisfy the standard of dwelling together.
Great. Good afternoon. This is the matter of Bolensky versus Gardner, case number 23023131DM, present in the virtual courtroom. We have both parties along with their respective attorneys. This is a continuation of a hearing on a motion to terminate spousal support and attorney fees that we began on June 5th. There's a stipulation, I believe, regarding an additional exhibit or a completion of an exhibit, supplemental exhibit. I don't know what to call it, but Mr. Sherlin?
Yes, Your Honor. It would be another version, a later version of what I believe we used as Exhibit J, report of investigation by Special Investigations Group. And I do need to email that version to the court. I'll copy Ms. Bryan on that email. I believe that was initially Exhibit J.
Okay. Ms. Bryant?
Thank you, Your Honor. The court may recall that I had issued interrogatories to Mr. Gardner, and interrogatory number 3. Interrogatory number 3 is the question where I asked for him to produce a complete copy of tangible evidence obtained by the investigator, including photographs, GPS data, reports. Mr. Sherlin and his client objected to producing that. I filed a motion for an order compelling that information, and we agreed that a complete answer to interrogatory 3 would be provided. That order was entered by the court March 27, 2026, and I'm referring specifically to paragraph 1C, C as in cat, which is the provision that says he had to complete and provide the complete copy of the surveillance report. Following entry of this order, I received a surveillance report, and it is the one that was first disclosed, I guess, as Exhibit J. And it says at the bottom of that report, date prepared July 30, 2025. So relying on that, we proceeded with our hearing. And then, as the court recalls, at the very end of the last hearing, we learned through the private investigator 2 things. One is that they did not provide the GPS data, even though it was specifically requested in the interrogatory. And secondly, we learned that there was an updated report, and the report is actually dated August 25, 2025, not July 30. And I think that's important for the court to note because of the fact that the date August 25, 2025 is long before the scheduled date of this hearing. I appreciate the fact that mistakes are made with regard to things. I didn't realize. I'm not asserting bad faith on the part of Attorney Sherlin, but most certainly this report was one that was distributed at least to the client and was paid for, and it should have been produced. And, we look at the issue of sloppiness or we look at the issue of intention. Either way, I did not receive that report in compliance with the court's order. And as the court knows, under the court rule, when someone doesn't comply with the discovery, we can be awarded attorney fees for that, and that's part of our attorney fee claim. My next comment about the report is that it is essentially the same information which the investigator, Mr. Kamenga, testified to. It's the same dates that he already covered in his last testimony. And if you remember, there was testimony that the car was in the Grand Rapids area. And of course, there was also testimony that the same car left and went back to Wisconsin and stayed for a lengthy period of time. That information, of course, is not within the report, only the stuff favorable to Mr. Gardner. So due to the fact that it covers the same dates as information already supplied by the investigator, I'm agreeing that it can come in. But I'm not making that agreement without my strong concern and request for attorney fees as a result of the fact that this report was not provided to me in compliance with the discovery request or the court order. And it didn't necessarily put me at a disadvantage because it is the same information, but it's very frustrating that I had to incur the additional fees to, cover additional pages that, I should have been provided a long period of time. So with that, I want to be fair to the court. I don't want to create an appealable error. So I am allowing and stipulating that it may be entered, the new report dated August 25 of 25. It may be admitted in its entirety, but with my strong request for attorney fees because it was not provided in compliance with the court's order.
Thank you. It is admitted, and the request for attorney fees is reserved. I guess it's part of what the decision the court will be making.
Thank you.
All right, Mr. Sherlin?
Your Honor, with the admission of the investigative report, I don't have further witnesses.
All right, Ms. Bryan?
Your Honor, I call Ms. Belinsky as a rebuttal witness.
All right. Ms. Belinsky, would you raise your right hand, please? Would you state your name and spell it for the record?
Karen Belinsky, KarenBalinski.
Do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Karen, I want to ask you some questions about the information that is contained within the August 25 surveillance report. After our hearing, did you work with me in my office to review all of the exhibits that the investigator has now supplied?
Yes.
And did you also work with me in my office concerning all of the other exhibits that were prepared by and offered by Mr. Gardner, your ex-husband?
Yes.
And with that information, did you work with us to prepare a calendar to outline the dates of the exhibits which show Mr. Dolangowski in the photographs?
Yes.
And is that the document that you have in front of you?
Yes.
Your Honor, may I screen share the proposed exhibit?
Yes, you may. Just make sure there's no personally identifying information on it. That's fine.
Okay. Is it this one? No. Is this the document that we just described, which shows the dates of the different photographs that have been admitted as exhibits?
Yes.
And with regard to the information that's at the top right here, does it show the yellow? Those are the dates of the photographs provided by the investigator?
Yes.
And the green circles are the dates of the photographs provided by Mr. Gardner?
Yes.
And red are the new dates provided by the updated report, August 25, 2025?
Yes.
All right, move for admission of exhibit 19.
As a demonstrative exhibit, Your Honor?
I'm offering this as a rebuttal exhibit.
I don't necessarily have any objection to the exhibit itself. I just, I guess I don't know that the foundation for the dates has been laid.
I already indicated that she reviewed every single one. If you want us to take the time to go through every single one, we could. But I think that doesn't make a lot of sense to do that. You could always tell us if we missed one.
I guess as far as admissibility, Your Honor, I have no objection.
All right, it's admitted. Thank you.
And Karen, with respect to this calendar, there's a period of 3 weeks here, 2 weeks in July, 1 week in August, where Mr. Dolangowski was at your house. Is that correct?
That is correct.
And after you saw the updated report, did you go back in your records to figure out why he was there for 3 weeks?
Yes, I did.
And why was he there for 3 weeks?
I had a new litter and he came out to help.
Okay. And was there another event that created a problem which extended his stay?
There was, on the 31st, a tree branch fell on my car and damaged it.
And so why did that mean that he had to stay longer?
I ended up needing a rental and the rental company does not allow dogs or puppies in their cars.
Why did you need to have dogs or puppies in your car?
I have various vet appointments that I need to get to. So in order to get the animals to the vet appointments, I needed to have a vehicle I could put dogs in.
And why was he needed to help you with that?
Originally he was going to go back earlier, but again, I just needed to use the van and be able to get the dogs to the vet appointments.
Now, based on the testimony from the investigator at our last hearing, they tracked his vehicle leaving on August 9 and then returning to your home. And where did he go when he left on August 9?
He went home.
Which is where?
In Wisconsin.
And then according to the investigator report, he returned on August 22 or 23. Why did he come back?
He was returning the van.
Why did you let him borrow your van and go to Wisconsin for those 2 weeks?
I had offered the use of the van for him because he needed the van for a job that had like large lumber and material. So I had offered it to him because I also had a puppy that was going to Wisconsin. So the agreement was he was to transport the puppy, use the van, and then bring the van back.
And then did he stay for a longer period of time after August 23?
No, he did not. He stayed for 1 or 2 days and then he went back home to Wisconsin.
Okay. Additionally, according to your ex-husband, he photographed Jay on some other dates in September, one in October, one in November. Do you have any reason to dispute those dates?
I do not.
Okay. November 25 or 26, he came back. What date? What is the significance of that visit?
That was the day before Thanksgiving.
All right.
I had multiple people over for Thanksgiving.
And he was one of your guests?
Yes.
And then with regard to the Christmas, I think that's December, it's small there, but it's December 25, is that right?
That is correct.
And why was he there?
Again, he came for Christmas and he actually left on the 25th.
Okay. All right. Let me see if I can get rid of this. Then additionally, he testified, he went through all of his photographs in his testimony and he indicated that he had photographs of Mr. Dolangowski. Did you go back and look through those photographs?
Yes, I did.
And were there any photographs which he claimed to be Mr. Dolangowski, of which you would disagree?
Yes.
And what one was that?
There was one where there was a picture of my friend Alex walking across the driveway, and he claimed that was Mr. Dolangowski, and it was not.
Okay, let me see if I can screen share that. So this, I'm showing you exhibit Z-LL. Do you see that?
Yes.
And there's an individual there. Who is that individual?
That is my friend Alex.
And that is not Mr. Dolnagowski?
That is not Mr. Dolnowski.
How do you know that's Alex?
Alex is taller, and just from, the clothing.
Okay. When was the last time that Mr. Dolnagowski spent an overnight in your home?
That was, April of 2026.
And then have you been to his home since April of 2026?
No, I have not.
Have you been to his home since we were last in court?
No, I have not.
Has he been to your home since we were last in court?
No, he has not.
Are you still maintaining a relationship with him?
Yes,
So that hasn't broken up,
that has not broken up.
but he continues to live and reside in Wisconsin?
That is correct.
That's all I have. Thank you.
Mr. Sherlin?
Thank you, Your Honor. Ma'am, why did you need a rental vehicle?
Because my car got damaged by a tree branch.
Well, you have two vehicles, don't you?
Yes, I do.
So you needed a rental vehicle because Mr. Dolnagowski had the other vehicle, correct?
The other vehicle was currently at my house, but I still got a rental.
So you got a rental but left the other vehicle, the Honda Odyssey, undriven?
The Honda Odyssey we were using to drive to the airport or to the vet office.
Okay, Mr. Dolnagowski was using the vehicle, the Odyssey?
Not while it was at my house, I was using it.
Okay, and then where is the Honda Odyssey right now?
Currently, right now, it's at my house.
Okay, when did it return from Wisconsin?
I would have to go back and look at my records. It's been at my house for a bit.
A week or 2 weeks or a month, you know?
I don't keep track, to be honest.
Okay. Your Honor, those are my questions.
Ms. Bryan, any follow-up?
No follow-up.
All right. Any additional witnesses?
No, thank you.
All right. Statements. Closing argument.
Thank you, Your Honor. Would you like me to proceed first?
Sure.
Thank you. Your Honor, I'd ask the court to consider that the totality as envisioned by Smith v. Smith demonstrates that there has been cohabitation. Cohabitation is a terminating event pursuant to the judgment of divorce. I would ask the court to also take into consideration the unpublished case of Herman v. Herman. It's Herrmann. The Court of Appeals number is 306568. Herman talks about the financial dependence between the parties. And I think that's clearly what's happening here. While the parties don't share accounts per the testimony, bank accounts, for instance, or own property together, the financial interdependence pursuant to Herman, analyzing Smith, indicates that that dependence should weigh in favor of cohabitation, Your Honor. The surveillance period here was a set of information, a subset of information, if you will. The periods, for instance, in the report show from July 11th to August 23rd. The photographs that were admitted into evidence show additional dates where my client, only when he was appearing for his parenting time, had an opportunity to view and photograph Mr. Dolnagowski at the residence. We clearly understand that that the plaintiff has the opportunity to date and has the opportunity to be in a relationship. It's really a question of whether these parties are enmeshed to the point where they've changed the nature of that dating relationship to more of a, I guess, a cohabitation. And I was struck by the fact that Mr. Dolangowski testified that he doesn't file tax returns, that he really couldn't state an income, although I think the plaintiff had that same difficulty in terms of stating her income. And we learn as Mr. Dolangowski is testifying that he's really at his son's residence. I think that's what I heard him say. And that he has Ms. Belinsky's vehicle in Wisconsin. And I apologize if I get it right, but I know it was an extended period of time. I thought I remembered hearing a couple months, but maybe I'm wrong. Certainly I heard it was there for an extended period of time. And even the dog business seems to be intertwined. Although Ms. Belinsky characterized Mr. Dolangowski's involvement in the business as a paid employee, I don't think any records were presented to demonstrate that that was a legitimate business expense, or even characterized, through a 1099 or a W-2 as income to Mr. Dolangowski. I really think, Your Honor, that the totality shows that the parties really are hoping that my client would simply ignore what was going on, and that they would continue to really just kind of do what they wanted. And from the totality of the evidence, I think it shows that they were cohabitating. As far as attorney fees go, Your Honor, my client doesn't have the ability to pay attorney fees. I think that was clearly demonstrated by the proofs. He is paying substantial sums of money to the plaintiff, and certainly that factors into his ability to pay attorney fees. And the required proofs include a demonstration of my client's ability to pay the plaintiff's attorney fees. I would argue even that the plaintiff, I don't know that the plaintiff demonstrated that she has a need for attorney fees either. I think that the information received by the court regarding the plaintiff's income was very intentionally vague on the part of the plaintiff. I think there was testimony offered and evidence offered that there were a number of income opportunities in the form of these puppies that certainly didn't seem to be reflected in the plaintiff's income tax returns. So I'd ask the court to consider that certainly my client doesn't have the ability to pay, but I'm not sure that the plaintiff has the need either. As far as the attorney fees related to the investigative report, Your Honor, I appreciate opposing counsel acknowledging that it wasn't done with ill intent. I simply provided the report that I believe to be the complete report. I think the point is, though, that there was an acknowledgement, I appreciate the acknowledgement, that there really wasn't any prejudicial effect associated with the two versions of the report. So I'd ask the court to consider that my client has demonstrated that there sufficiently that there is cohabitation that has occurred, and that the spousal support obligation should be terminated. I suppose there's the question of what if the court terminates spousal, when should it terminate? I would ask that it at least terminate at the point where my client provided notice of his request to terminate. I don't know if there's authority that allows the court to terminate at a prior date based on demonstration of when cohabitation may have occurred, but if there is that authority, I would ask the court to apply the earlier date. And I would ask the court to deny the plaintiff's request for attorney fees from the defendant. And also maybe just a reminder that we still have the parenting time portion of the evidentiary that we just scheduled, and that does include my client's request for attorney fees based on the non-compliance with the terms of the judgment of divorce as it relates to parenting time. Thank you.
Thank you. Ms. Bryan.
As I prepared for the hearing today, I spent some more time looking at the Smith decision and was reminded that there are really 3 categories of examination for the court to consider. The first is the living arrangements. The second is the personal relationship. The third is the financial arrangement. And under each of these categories, the court of the opinion suggests that a trial court look at certain aspects of a case. And I think that when you look at the 3 arrangements, you will conclude as follows. 1, what is the living arrangement of the parties? There's no question that Mr. Dolangowski is a Wisconsin resident. And importantly, that is something that Mr. Gardner knew when he filed this motion. His investigator provided him with the same information that this gentleman was a Wisconsin resident. And I think that's important for the court to reflect on, because he knew going in what he was going against, and whether he was just going to roll the dice or not was really up to him. The living arrangements are that the parties do have separate residences. There was no testimony to indicate that Mr. Dolangowski has a key to her residence. There was no testimony to show that he used her residence as a mailing address. There was no testimony that they were sharing household duties as though they jointly owned the house. The most that they have is that when they had a meal, maybe he picked up his dish. That doesn't come close to meeting the threshold necessary to terminate someone's right to spousal support. We go next to the personal relationship. Well, there's no question that my client has a personal relationship, a monogamous relationship with Mr. Dolangowski, and she has every right to do so. If this was just a question of someone dating someone in a monogamous relationship, that would terminate everybody's spousal support. So it's got to be more than that. Was marriage contemplated according to the Smith case? And there's no evidence that marriage was contemplated. They're not interested in that. The Smith case says, did they spend vacations and holidays together? Well, we do know that they tried to spend some holidays together, Thanksgiving and Christmas, according to my client's testimony. But much more than that, there's nothing. They didn't go on vacations together. It says, how does the couple represent their relationship to their family, friends, and acquaintances? How did those people view the relationship? Well, again, we have no evidence to help Mr. Gardner on that aspect of this because my client indicated that she introduces him, her boyfriend, as Dave. Not Dave, her boyfriend, or Dave, my husband, or Dave, my common law husband, just Dave. So with respect to that second important factor, really, there's nothing more than she has a personal relationship with this gentleman. The third prong of the Smith case is the financial arrangement of the parties. Do they share expenses? They do not. And Attorney Sherlin has come up with nothing to show that they do. She pays for her own utility bill. She pays for her own mortgage payments. Nothing has been presented to contradict that fact. Do they jointly own real estate together? No. Do they jointly own personal property together? No. Does one party support the other? No. He's had all the opportunity he wanted to look through all of her bank records. Nothing has been shown to this court that she provides support to him. What she has said is that when he transports a dog for her, that she pays for the gas. That's hardly taking care of his personal expenses. And I acknowledge that Mr. Dolangowski indicated that he doesn't file a tax return. Well, what does that mean? Does that, the fact that he wishes, or maybe that his income isn't sufficient to file a return, or he just chooses not to, that has nothing to show any interdependence on the part of my client. But my client showed her tax return. So to make a claim and say, oh, she hardly showed anything with respect to her income is completely untrue. She provided her tax return, she provided her income, and they had every opportunity. They had 90 days of discovery to look into all of that information, and they either chose not to do, or they found nothing to show you. So this is not a situation where he has come close to establishing a cohabitation. My client has every right to have a boyfriend, and to have her boyfriend stay in her home for periods of time, such as what has been shown to the court. And I hope that the court finds the new rebuttal exhibit to be helpful, because when you look at the evidence that they've shown, there are only 34 days out of 365 days that they've shown that Mr. Dolangowski has spent the night or been at her home. And the biggest period of time was at the end of July and the first week of August, when my client indicated that she was managing puppies and needed help with managing puppies. This is kind of ridiculous that we're here and that we're even having to argue these issues. The reality is that these, my client and her boyfriend have distinct financial independence. They have separate residences. They live in different states, which, by the way, is exactly the facts of the Smith case. We already know that someone having regular sleepovers does not satisfy the standard of dwelling together. There is no economic partnership, and spousal support is based on need, which she needs desperately in order for her to continue and financially support herself and the two children. There are no sharing of debts. There are no buying of assets together. There is no financial dependence that has been demonstrated by the plaintiff at all. And it's his burden to do that. No sharing of accounts, no sharing of expenses. Now, I heard a comment by Attorney Sherlin that somehow the dog business is intertwined. Well, we acknowledged that her boyfriend has helped her transport a dog. That's hardly intertwined. That's not any different than someone else with a small business turning to a friend to help out here and there, and that's what she needs to have. And when you look at her tax returns and look at how little income she has, you can appreciate why she would need to turn to a friend, whether it be a man or a woman, to help out. I want to go to the issue of attorney fees. As the court knows, I filed an amended motion to distinctly lay out all of the reasons why we are entitled to an award of attorney fees. And we are relying on the claim that Mr. Gardner has substantially more income than my client. And by the way, it's income, not assets. We have an agreement that he owes her a property settlement, and we know that he's got to make those property settlement payments. Those are her assets. And if she's asked to pay for the extensive attorney fees that have already been incurred in this case, then he's got to contribute to that because he has more income than she does. And I believe I recall that in my cross-examination of Mr. Gardner, he agreed that her income, just looking at income, is about, I think it was 10% of his. So to come in today and hear an argument, oh, he doesn't have the income, he does have the income. It's right on his tax returns. And that's what the court is required to look at when assessing the request for payment of attorney fees. So we would ask that the court grant the request for a payment of attorney fees. I know that another hearing needs to be held as to the reasonableness of those fees, and I know that we haven't addressed that. I think that's a second step in terms of the reasonableness of fees. We're prepared to show the court that the fees that she has incurred are reasonable, particularly the work that we've had to go through in order to get the plaintiff, the defendant rather, to simply answer straightforward interrogatories and exercise good faith by giving us complete documents. So I would ask that the court reject the claim that my client is cohabitating and award her the actual attorney fees that she has requested as set forth in the prior exhibits that we've admitted.
Thank you. Mr. Sherlin, did you have any rebuttal?
Very briefly, Your Honor. I don't know that I referenced that my client doesn't have income. I specifically argued that he doesn't have the ability to pay based on the circumstances as they were laid out in the proofs. But Your Honor, I'll leave the court with this. I understand the most recent exhibit that we entered today. And I look at the highlighted portion. I understand that testimony to mean Mr. Dolangowski was present from July 20 to August 9. I believe that's what I heard. And he was there with the stated objective of helping with the puppies. So if that information is correct, if I understand that information correctly, that means that there was this extended period of time that he resided at the home and that he was there to help with the puppies. To me, Your Honor, that's intertwined. Thank you.
Right, thank you. As a housekeeping matter, first of all, I am going to take this under advisement. And Mr. Sherlin, we still need your exhibit.
I was trying to do that while we were working on this, Your Honor, and I'm not that great at multitasking.
That's okay. I'm glad you didn't disconnect yourself. So
Okay.
Yeah, if you could just send that over as soon as you
I
can.
will do that as soon as we leave the hearing.
All right. Anything further?
No, thank you.
Okay.
No,
we adjourn.
thank you, Your Honor. Thank you.